I'm Kerrigan back with you on the Law Show. Thank you very much for watching, and thank you all very much for sending us text messages, which you do from time to time. You can text us right now during the show. We'll answer that. It's 850-444-4444. Not exactly a hard number to remember, but calling us, just dial the fours. You dial 4 till somebody answers. Okay, that'll be us. But the text message, you have to have 850 preceding it, 444-4444. You can email me if you want to directly, bob@kerrigan.com, or you can email any of the partners of the firm and by accessing our website, which is kerrigan.com on the screen behind me. And that's one of our offices there. That building is downtown Pensacola, Florida. Glad for you to be with us, and send along anything you think we should talk about, anything that you think is of interest. We do specialize in injury and death claims, but we're here with the Law Show answering questions about the law general. If we know, if we don't, we will send a message or the inquiry on, or recommend that you contact somebody else that knows about your area of need, whatever that might be. And the Florida Bar has something called the Florida Bar Referral Service, which is a toll-free number in Tallahassee that you can call to have cases, to secure a lawyer for the kind of case that you have. Our cases, the cases our firm handles, are injury and death claims, and all of our partners are board certified, and we're all well experienced in these cases, have handled them for years and years, all over every kind of case you can imagine. And from airplanes to trains to trucks to cars, medical malpractice, products liability, prescription drug issues, they're all under the umbrella of the kinds of cases that we undertake. We covered the grand jury issues, the big picture of grand juries. For those of you who haven't been with us on previous programs, we discuss the state grand jury system, the statewide grand jury system in Florida, and the federal grand jury system. So if you have any questions about that, you can text me or email. We've covered that in the past, but if you missed it and you have an interest in that, you can tell me. Well, now I want to talk about something that is very common, because you can't watch a television program and have a commercial at some point in time in the evening that isn't about lawyers advertising that they're taking cases on certain kinds of drugs. The disclaimer that's on the screen is a travesty. If you've seen it, it is probably 13, 14, maybe longer lines of small print text on the screen that you couldn't possibly read in a million years for watching the TV commercial. And I don't know what the purpose of it is. Well, you have to do it. Legally, you have to do that. Well, it doesn't mean anything because you can't read it. It's like having small print on a billboard. Nobody's going to read that. But you met the letter of the law. Well, the law shouldn't be the letter of the law. It ought to be the substantive meaning of the law. It should protect people by having false or misleading information displayed. So I find fault with these advertisers for these drugs. But what kind of cases are they? What are you talking about? Well, you have cases that involve many, many clients. They're called either class action cases or mass tort cases. Well, what's the difference? Let me give you an example. Say a grocery store that has 10 million customers and all of their chains and whatever, any kind of big store, and they overcharge every customer a penny. Well, you couldn't bring a lawsuit for a penny, right? I mean, who'd do that? You have to pay a lawyer to get a lawsuit for a penny? And they say, well, you only lost a penny, so what are you complaining about? So class action suits are designed to bring claims against some entity, a business or whatever, that's overcharged or mischarged or whatever, small amounts, to millions of people, hundreds of thousands, if not millions of people. The criticism of class action suits always comes from the organized business and the insurance industry, because they're the ones that have to pay, okay? The insurance companies have to pay usually, or the corporation that is taking the money. So this corporation that charges millions and millions of customers a penny more, and so they add $8 or $10 million to their bottom line, whatever the number turned out to be. So they're in great shape, and if anybody sues them, they only have to pay a penny, okay? Well, class action suits are suits that require them to refund that penny or some other remedy, a coupon or something else, to the people that have been overcharged, the customers. And a penny's not the best example, but a small amount of money, okay, would not justify bringing the claim yourself. You just wouldn't do it. So that's class actions. The criticism is, oh, well, the lawyers are making all the money. Well, that's true. The lawyers will make money by doing it. They get a percentage of what they recover. And yes, they're going to make a lot more than any particular claimant who gets an airline ticket or gets a coupon or something else, in terms of the penalty. But the idea is we can't allow businesses to overcharge or take tiny amounts from millions and millions of people. We have to have a way to stop that. And a class action suit is designed to stop that, to make the people who've receive this money that they should not have received have to give it back or something equivalent back so that they don't profit by their own wrongdoing. It's a very simple concept, okay? It's widely misunderstood, and it's openly criticized by the people who have to pay it back. And they always say the same thing: greedy lawyers, greedy lawyers. I suppose everybody's got a level of greed to them, but greed has nothing to do with it. The lawyers are compensated for making the wrongdoer not profit by it. It's good stuff, and it's just the fabric of fairness. Class action suits are prominent in it, and the fabric of fairness, okay? Now, what about mass torts? What's the difference? Involves a lot of people. Everybody, for example, that took a particular weight loss medication and suffered kidney damage, let's just say, as an illustration of that. And you have like 5 million people maybe that took this medication and suffered kidney loss. The difference between a mass torts and a class action is this: where you have mass torts, you have the same wrongdoer, but you have greatly different damages depending on the individual. A person may have mild kidney problems. A person may have mediocre kidney problems. A person may have lost a kidney, or a person may have suffered some kind of cancer development because of this drug. So you have individualized damages, but you have a common wrong. Just like the company that overcharged everybody a penny, it's a common wrong. But the difference is, with mass torts, people have individual claims. Big difference, and they are not the same. They're usually in categories of claims. The criticism of mass torts is it's a business representing, thousands and thousands of people. You don't have the personal relationship between the lawyer and the client. They process claims involving, thousands and thousands and thousands of claims, and lawyers make a lot of money. And the result is good. It's better than you bringing the claim yourself for this reason. Let's say you have a case involving a drug that has caused kidney damage, for example. And you attempt to undertake that case, and you're going to sue a big manufacturing company or a major corporation. And let's say your claim's worth $300,000 or $500,000, whatever, less than $1 million. It's very hard for a lawyer to undertake that case, undertake that risk, advance all the money necessary to go up against a major corporation for an individual to be able to recover. So that mechanism of mass torts allows that kind of person to make a recovery at a standard contingency fee, which might be anywhere from 15, 20, 25, 30%, whatever it is that the individual person will have to pay. They're still better off than to try to do the case themselves. In most cases. Let's say, however, your case involves the loss of both kidneys and a shortened life expectancy, and your claim is worth $5 million. Well, in that case, it may be wise to undertake the case individually with a lawyer as opposed to participation in a mass torts settlement. They generally have categories of recovery for mass torts. It'd be like mild damage, medium damage, great damage, something like that. But they may not have a category for the claim, for the loss that you have incurred, which might be catastrophic. And so that catastrophic claim should be evaluated by a lawyer to see whether it is wise for you to participate in a mass tort settlement process. Okay? And that can be evaluated by a lawyer. Many times, mass torts have been the only way you can make a recovery. And one of the champions of it in our area, which is remarkable, really, is Mike Papantonio. He was just remarkable in his early understanding. He's with the Levin firm. His early understanding of it. And Ailstock now is another local firm. They do a really good job with mass torts. But Mike Papantonio, he had the vision before anybody else did about how mass torts would work. And he's been very, very successful. He's recognized nationally for his work in that field. That's Mike Papantonio of the Levin firm. You're watching the Kerrigan, Estes, Rankin, McLeod, and Thompson's Law Show, where we talk about the law. Our firm specializes in injury and death claims. All of our partners are board certified and well experienced, and we have the highest ethical and legal rating by Martindale-Hubbell that you can obtain, and we're proud of that. Proud of the work that we do and the clients, the thousands and thousands of clients that we have. Please see our Google reviews on our website at Kerrigan.com. So until next week, Bob Kerrigan saying thank you very much for watching the Law Show. Be safe, and we'll see you next week.